Today we're going to have a look at the three certainties of trust law, which are the certainty of intention, the certainty of subject matter, and the certainty of objects. This video will be all about certainty of intention, the first of the three certainties. So, the case Knight versus Knight in 1840 confirmed that we need these three certainties in order to create an express trust. First of all, we're going to be looking at testamentary trusts and the requirement to have duty-imposing words. So we're going to go through the case law in order to find out what the courts have held to amount to duty-imposing words. The importance of having these duty-imposing words is because we can't create a trust without knowing what the settler's true intention was, and these duty-imposing words tell us with certainty that what the settler intended was to create a binding trust. So we're going to start with the case of Adams in 1844, in which case the testator wrote the property was being given in full confidence that the recipient would do what is right. And the court said that this was not sufficient for a trust to arrive, so in full confidence was not enough to show duty-imposing words and the intention to create a binding trust. Next, we'll have a look at the case of Lamb versus Eames in 1870, in which case the testator gave his estate to the widow and said, the estate was to be at her disposal in any way she may think best for the benefit of herself and her family. So, this case was contended because after her death, she gave part of her estate to the illegitimate son of one of the testator's children. So definitely not someone in the family that the testator had in mind when he created the will. But it was held that his wording was not precise enough to amount to duty-imposing words, and therefore the estate that he had passed on to her was an outright gift and she could do whatever she pleased. She was not bound to spend the money in a way that complied with his wish and his words of desire. So she took absolute ownership of the assets that she was given. Next, we will look at the case of Hamilton in 1895, where the court said that the words "I wish" are also not sufficient to create a binding trust. And then in Johnson in 1939, the words "I request that" again were not sufficient to create duty-imposing words and a binding trust. And now it gets a bit more interesting when we look at the case of Comiskey in 1905, because we will recognize that where the words "absolutely in full confidence" are used, this reminds us of the earlier case of Adams, in full confidence. So these were held in the previous case to be words of desire and not amounting to duty-imposing words. However, in the Comiskey case, he did not only say absolutely in full confidence, but he made a later statement in the will stating, "I hereby direct that all my estate and property acquired under this will shall at her death be divided equally." So, therefore, the first statement only contained words of desire, so the absolutely in full confidence are still only held to be words of desire. But the court said that the will as one document has to be interpreted as a whole, and the second clause makes it very clear that the testator did not want her to be able to completely freely decide how to use his assets. And therefore, these words were duty-imposing and a binding trust was created. So because the will was read as a whole, not each provision was interpreted solely, and there could be a binding trust. Next, an interesting case as well, Steele's will trust in 1948. So in this case, the testator used the following words: "I give my son my diamond necklace to be held by him and by his eldest son on his decease and so on, and I request my son to do all in his power to enforce this wish. So, initially we think, again, this sounds like words of desire. This doesn't sound like amounting to duty-imposing words. However, the courts regarded the fact that he had used these words specifically because he had knowledge at the time of creating his will that there was a valid precedent that these specific words, I request, all in their power to enforce a wish, was sufficient to create duty-imposing words and a binding trust. And this made his intention sufficiently clear. So because of these specific words used, because of the knowledge that they were a precedent at the time, there was sufficient evidence for the court to hold that a binding trust was meant to be created. So next we're going to have a look at inter vivos trusts. These are trusts that take effect within the settler's lifetime. Here again, they can be created through duty-imposing words, but they can also arise in certain circumstances informally when the settler's words and actions can be interpreted by the court to show this duty-imposing intention to create a binding trust. And we're going to do this again by looking at the case law and which type of actions and words the courts have informally held to amount to a binding trust. So, first of all, we will look at Paul versus Constance in 1977. And this case concerns a couple where the man gets a compensation payout from work and he deposits this money in a bank account. When he sets up the bank account, he asks the bank manager whether his girlfriend can also access the money. He makes multiple declarations during the relationship that the money is as much hers as it is his. And, for example, they regularly play bingo, and all of their bingo winnings are paid into the same joint bank account. And there's only ever one substantial withdrawal made, and this is spent on both of them, so for their joint enjoyment. When he dies, he does not leave a will, and although he was living with his girlfriend at the time, legally he was still married. So then his wife is appointed as the administrator of his estate. And then we have a situation where the girlfriend sues the wife, stating that the money in his bank account was held on trust for the joint benefit of her and him. So the court ruled that although there was no written document, due to the lack of a will or a declaration of trust instrument, due to his words and actions, there was sufficient evidence that he had intended to create a binding trust. It was for their joint benefit, so she was entitled to half the money. And now we must consider that although the decision seems fair, it is slightly problematic, because it's unclear at exactly what stage his words and actions are sufficient to provide this evidence of a duty imposing intention. So the question is it when he asked the bank manager at the beginning? Probably not, because that would probably not be sufficient to show a duty-imposing intention. Is it when he tells her that the money is as much hers as his? Or is it when they pay in their joint winnings, or when they make the withdrawal for their joint benefit? So the problem here is, at what stage is the tipping point? At what point is the evidence sufficient? Then later, we'll look at the case Riosoba in 1979. In this case, it's actually held that in cases such as Paul versus Constance, the girlfriend should have been entitled to the entirety of the money, because when there are no words of severance, the beneficiaries hold as joint tenants, which means that by the right of survivorship, the girlfriend should have been entitled to the entirety of the money. But obviously this case was decided after Paul and Constance. So next we'll look at the case of Roe versus Prance in 2000. And this case concerns a couple that has a 14-year affair. The man is still married, but he keeps indicating that he will leave his wife, but he never quite does this. So during their relationship, he buys a yacht and he tells his girlfriend that the plan is that once he leaves the wife, they will live in it together. The money to buy the yacht comes from himself and is also registered in his name, although this owes in part to the fact that he lies to his girlfriend and tells her that it must be registered only in his name because she has no ocean master license, and this is a lie. So she is the one who negotiates the purchasing of the boat, and she also gives up her rented accommodation to move to the boat. So we can tell that she does play a substantial role in acquiring this boat. And he always refers to the boat as ours, and he also states that the boat meant that she is financially secure despite giving up her accommodation. And a few years afterwards, they separate. And the girlfriend goes to court and states that the boat is being held on trust in equal shares for both of them. And the court holds that there is a valid trust because he had shown the necessary evidence of intent through his actions and words. So next we will have a look at whether there can be an intention to create a trust when there is mixing of trust property. So there is obviously a trustee duty to keep assets separate from the trustee's own assets, so to ring-fence the assets. And if the settlor does not give the instruction to the trustee to separate assets from their own, this can be a good indication that creating a trust was never the intention of the settlor in the first place. So again, we will have a look at some case law. We'll start with Cayford in 1975, where it was held that the separation of customers' money in a different bank account showed sufficient intent to create a trust. So separating money is absolutely fine to show intention to create a trust. In Kinloch, however, and this is very important, Kinloch 1882 states that there is no magic word, such as the settlers saying they want to create a trust, that will actually mean that they have met this duty-imposing requirement. It is not only based on the words they use, but also on their actual intention, and this is what the court tries to extrapolate. So there are cases where settlers use the word trust, but they're still found not to have had the intention to create a trust. So next we'll have a look at the Richmond Theatre case, where exactly this is of interest. And in that case, a theatre stated that for people buying their tickets, the money was held on trust for the individuals. However, they also stated they would not be accountable for interest or in any other way for any liabilities. And this actually indicated that it was actually not a trust in the first place. So therefore there was no trust created, and there was just a creditor-debtor relationship between the theatre and the individuals. Next, the Leicester case in 1995. So in this case, it was held that some mixing of money can be okay, but only in the situation where the trustee has money in a separate bank account that he's holding on trust, and then he adds some of his own money into that pot, so to say. But he still knows that he's holding that money for himself and the other for the beneficial interest of the beneficiary. So there's still an element of separation. So that is the only situation where there can still be intention. Next, we will have a look at whether there can still be an intention to create a trust, a binding trust, when the trust itself is a sham. So, in the case of Midland Bank, we have a case where a businessman wanted to shield his family home from financial risk. So what he does is he makes a document stating that he's holding his house on trust for his children. But he takes this document and he locks it into a safe, and he never tells anyone about it. So when he then goes bankrupt, the question for the court is whether this document was a binding trust and had any effect. And the court held that it was not, because he'd only tried to ring-fence his own assets, and he never intended to give his daughters a beneficial interest. So in this case, it was held that there was no intention to create a binding trust, because the trust itself was a sham. And lastly, I've mentioned it already today, but just to enforce it again, in the case that a trust is not held to have certainty of intention, and it is held that the settlor did not intend to create a binding trust, instead it will be held that the beneficiary takes the property absolutely. So this means that they have absolute ownership and they can deal with the asset in any way they wish, and are not bound by the words of desire of the settler. Thank you very much for listening. I hope that I could explain certainty of intention to you today. I'm more than happy to answer any of your comments below, and don't forget to follow me on legally.blonde.laura on Instagram. Thank you.